Hello, everyone, and welcome to this comprehensive guide on Panama Private Interest Foundations. If you're exploring the options for asset protection, estate planning, or international wealth management, you've come to the right place. Today, we're breaking down everything you need to know about these powerful tools. We'll cover definitions, legal foundations, setup processes, key roles, benefits, differences from trusts, common questions, and more. This isn't just theory. It's actionable insights to help you decide if a Panama foundation fits your strategy. So let's dive in. First, what exactly is a Panama Private Interest Foundation? Often abbreviated as PIF, it's a legal entity created under Panama's Law 25 from June 12th, 1995. You can go look it up, which it's specifically designed for non-commercial purposes like asset protection, family wealth succession, and tax-efficient planning. Unlike corporations or traditional companies, a PIF holds and manages assets independently, shielding them from the founder's personal liabilities while allowing customized distribution to beneficiaries. Think of it as a hybrid between a trust and a company. It has its own legal personality, meaning it can own property, enter contracts, and sue or be sued in its name, all without the commercial intent required for businesses. These foundations emerged in the early 90s as Panama positioned itself as a global hub for offshore services, drawing from civil law traditions to appeal to international clients from Europe, Latin America, Canada, really all over the world. By 2025, PIFs, these Panama foundations, have evolved with minor regulatory tweaks like the December 2024 Executive Decree 177, which mandates electronic submission of basic accounting records annually to ensure a little bit of transparency without compromising privacy. This update aligns Panama with OECD standards, but keeps foundations exempt from routine audits unless investigations arise. Over 20,000 PIFs are registered today, managing billions in assets, from real estate and stocks to digital holdings like cryptocurrencies, NFTs, and ICO tokens. At its core, a PIF works by transferring assets from the founder to the foundation, which then administers them according to a private deed of foundation. This deed outlines the foundation's name, purpose, initial capital, board members, and beneficiary designations, none of which are public. The foundation's charter is registered in the public registry for validity, but internal regulations remain confidential, stored privately or with the resident agent. Assets become the property of the foundation, separating them from the founder's estate and providing a firewall against creditors, lawsuits, or forced heirship laws in the founder's home country. Now, let's deal with the key players here. The founder, also called the subscriber, initiates the foundation by signing the deed and contributing assets. They can be anyone over 18. No nationality or residency is required. You don't need to be a resident of Panama. And often a nominee, like a law firm, is used for anonymity. The founder can retain influence by appointing a protector, an optional overseer who monitors the board, vetoes decisions, or removes members if they stray from the deed's intent. The foundation council, or board of directors, handles day-to-day management, a minimum of 3 natural persons or 1 corporate entity. Again, with no residency rules. They act as fiduciaries, bound by duty to beneficiaries, and cannot personally benefit unless named as such. Beneficiaries receive distributions per the deed. Family, charities, or even the founder and their identities stay hidden. One standout feature is asset segregation. Once transferred, assets are foundation-owned, not revocable by the founder unless specified. This enables uses like holding foreign real estate, such as buying property in Europe via power of attorney to local agents, opening international bank accounts, or investing in DAOs and blockchain assets. For digital assets, PIFs are increasingly popular in 2025, with structures securing NFT portfolios or Bitcoin or token treasuries while complying with KYC via ultimate beneficial owner disclosures to the bank, the UBO. So, comparing Panama Foundations to trusts highlights why so many choose foundations. Both serve estate planning and protection ideas, but the differences are stark. Structurally, a trust is a fiduciary relationship under common law. The settlor transfers assets to a trustee who holds them for beneficiaries without the trust gaining independent personality. The trustee owns them legally. Whereas a PIF, rooted in civil law, is a standalone entity owning the assets managed by a board rather than a single trustee. Purpose-wise, trusts flex for the commercial or charitable uses, where PIFs focus on private, nonprofit goals like family succession, though they can hold company shares for dividend flow. So control varies. In trusts, there's different levels of control, but the settlor relinquishes all once assets are transferred, with trustees following the trust deed rigidly. The PIF founders can embed ongoing influence via the protector or reserved rights, like amending beneficiaries. Anonymity is high in both, but PIFs edge out with non-public internal rules and criminal penalties for leaks under Panamanian law. Trusts suit common law jurisdiction, like the UK or the US. PIFs thrive in civil law areas like Europe or Latin America for bypassing forced heirship, allowing you to disinherit spouses or children if desired. Finally, PIFs offer perpetual duration, without the 21-year rule some trusts face, and they're easier for non-US persons avoiding IRS pitfalls. The benefits are compelling. Foremost, you have ironclad asset protection. Assets in a PIF are shielded from the founder's creditors after a 3-year statute of limitations, unless fraud is proven, far stronger than many trusts. No attachment for personal debts, only for foundation incurred liabilities. You have the tax perks of zero income, capital gains, or inheritance taxes on foreign sourced income or assets. Panama taxes only local activities, and the PIFs report none, unless operating domestically. This makes them ideal for global portfolios, such as dividend income from US stocks, which flows tax-free to beneficiaries. Confidentiality is unmatched. Beneficiary names, asset details, and regulations never hit public records. Breaches face fines or jail. Estate planning bypasses probate. Upon death, assets distribute per the deed, ignoring home country laws, even derogating legitimate shares. No travel is needed. Setup is remote via email and DHL for originals. Flexibility shines for families, naming successors dynamically, supporting education and charity, or holding crypto securely. For businesses, PIFs own shares indirectly, enabling dividend payouts without commercial status. In DAO or DAO contexts, they protect member assets from hacks or disputes. Overall, it's a set-it-and-forget-it vehicle for wealth preservation with low costs amplifying value. Setup is straightforward. You'll need a unique name, which will be checked via the registry search, so typically you give us 1 or 2 backup names as well. You'll need a $10,000 minimum stated capital, but that doesn't have to even be deposited upfront necessarily. You'll need a non-commercial purpose and a Panama resident agent, such as a law firm providing address and compliance. There's no audits and no minimum subscribers beyond the founder. The lawyer will draft the deed, notarize it, and register it. The total time can be 10 to 15 business days to get things set up. You can also use a nominee board for extra privacy. And by the way, MyLatinLife, we can help you set up Panama Foundations. We can create structures with US LLCs and ways to combine the Panama Foundation with the rest of your personal and professional structure. So there's a link in the description where you can book a call with us, MyLatinLife, and we can start taking action. We can set up the entity for you. So if you're watching this video, you're probably researching your asset protection options. And if you're ready to hear from a professional, you're ready to start taking action, link in the description to book a call with us to get things started. So addressing some frequent questions, can the founder appropriate assets? No. Once transferred, they're foundation owned. Fiduciary duties prevent misuse, with beneficiaries suable for breaches. Another question, is the founder a beneficiary? This is optional, often not, to avoid piercing veils. Use nominee for setup. Another question is, what about commercial use? So indirectly, yes, you can own shares, you can receive dividends, but no direct trading. Is it foreclosable? Rarely. You have the 3-year protection window, only for fraud or foundation debts. What about inheritance post-death? Per the deed, successors are named, bypassing probate and home laws. This is huge, by the way. Bypassing probate is one of the huge benefits of these PIFs. Is the PIF amendable? Yes. Founders can revoke, alter, or dissolve at any time. Another question, what about foreign entities? They can adopt Panama law via migration. What about travel? None is required. This can be done 100% remotely, which is amazing. Myths abound. 1, PIFs are only for the ultra-rich. False. The ongoing annual fees are only in the couple $1,000 range. So as long as you're okay with, a single digit couple $1,000s a year to maintain the vehicle, then this is accessible for you, which makes it accessible for a lot of even mid-level professionals and families. 2, another myth is that they're unregulated tax havens. Wrong. Panama complies with FTAF, CRS. There are opt-outs for foundations regarding CRS, from my understanding. But the accounting rules, everything in Panama is, it's a top jurisdiction around the world. As we mentioned, 20,000 plus PIFs in existence today. Myth number 3, total anonymity is gone post-Panama Papers. Not quite. Beneficiaries stay private. Only UBOs report to banks. And then the fourth myth is it better than Nevis trusts? Well, it depends. PIFs win on civil law fit and perpetuity, but trusts edge out with common law simplicity. So if you're a tax resident of a common law country like Canada, the US, the UK, Australia, maybe a Nevis trust makes more sense because it's more compatible. But if you're a tax resident of a civil law jurisdiction like Paraguay, like Mexico, Spain, etc., then Panama might make more sense for that civil law fit. In 2025, amid rising geopolitical risks and digital asset booms, PIFs remain a top choice for diversification. They're not for everyone, so consult a specialist for your jurisdiction's interplay, such as EU reporting, but for privacy, protection, and planning, few match. If this sparked ideas, drop questions below. We'd love to hear from you guys. And please like and subscribe to the channel for more offshore strategies. Book a call if you're ready to take action. Thanks for watching, and we'll see you in the next video.